Well, hello. Today we are here for our second part of our two-part series regarding marijuana in the workplace. And we are going to be talking about different laws, state laws, as well as the ADA, that touch on or prevent employers from taking employment action against an employee who tests positive for marijuana. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
I know we're doing state laws as well as the ADA.
Mm-hmm.
As I mentioned to you before we went on air, I'm super excited for the ADA part of this conversation. That tends to be where most of my client questions originate.
Yes.
But I think it's just because people aren't aware of the state law implications here too. So let's start by eating our vegetables and then we'll get to dessert. Okay.
Fair enough. Fair enough.
Law part. I know everybody. I know state laws. We harp on that quite a bit. But
We do.
This is one area where there's just a huge variety amongst the states, and you really have to think about what state your employee is in, even if they are the only employee in that state working from home.
It is really important, and here's why. And by the way, it's particularly tricky maybe for listeners who primarily have employees in Michigan, but then in other states, right? Because in Michigan, this hasn't happened quite yet, okay?
What is this?
Well, it is, by this I mean laws that tell employers that they are not allowed to take employment action against an applicant or an employee because they've tested positive for marijuana.
Let's just pause there for a moment.
Yes, can we just let that sit for a minute?
I do think that concept is new.
Yes.
For a lot of people.
That's exactly right. I think that concept is new. And I think many HR folks would be very surprised to hear the number of states that have passed laws saying that. Now, to be clear, in some states, that prohibition relates only to medical marijuana.
Okay.
In some states, though, it also includes recreational use of marijuana.
So it sounds like using marijuana is a protected characteristic. Am I going too far when I say that? You know, normally when we talk about discrimination, protected characteristics, you can't take employment actions based on lots of things we shouldn't be doing, right? Race, color, religion, sex, etc. In some states, is marijuana use included in that?
Right. That's a great way to think of it. You are right. In some states, but not all. So again, listeners, employers who have employees working in different states, it's really, really important when you have a situation involving a drug test or marijuana to first, before you do anything else, know the law of the state in which that person is working.
Okay.
And you might know it today, but it could change tomorrow because this is it truly is a legal issue that is evolving, right? Yes. We're seeing these laws get passed.
Yeah.
And cities are passing ordinances now on this as well. So even though you asked and got the answer last year, you probably want to ask that question again. Call your legal counsel and make sure you know what law is going to apply in a particular situation involving an employee.
It is remarkable to me the evolution that we as a country have gone through from prohibited, illegal, to tolerated for medical, to tolerated for recreational, to protected for employment status.
I think probably our listeners are thinking, well, where, right? What states have this protection, particularly for just recreational use, right? So as of the taping of this episode, right?
Which we're never going to say because we want to replay this episode.
Right,
so.
Exactly.
You're going to have to call us. But
as
anyway.
of this moment, New York, New Jersey, Connecticut, Missouri, Nevada, and Montana all provide employment protection for recreational use. I will add, interestingly, California has been a little behind on this, which shocked me, but they did just pass a law that will become effective January 1st of next year, of 2024.
Okay.
And also interesting is Nevada has a law that protects against pre-employment testing at all.
Which makes sense.
Yes.
Because if you can't discriminate against someone based on a marijuana test, why would you allow the test to
That's exactly
occur?
right.
Just like we don't ask for people's protected status on employment applications, right?
Right.
There's no law that says you can't ask, but why would you ask if you can't use that information anyway?
So those are currently examples of states that prohibit employment action based on recreational use of marijuana.
Wow, what incredible movement we've seen. Okay.
So,
well, what about medical marijuana? This is where I continue to see employers have lots and lots of question and legitimate confusion, right? Because we think of...
Are you wanting to jump to the ADA already?
I kind of do, but
I do
two
think
more bites of broccoli first.
Yes, exactly.
Okay, tell me about where the states
I do want to
are.
go because I think there's an important point. I mean, we just sort of left it out there saying employers can't take employment action based on recreational use of marijuana. But I do think it's really important to make something really clear. Not a single one of those states, though, says that employers have to allow an employee to use marijuana while they're working. Or possess marijuana while they're working, or be under the influence of marijuana while they are performing work, right? So take a deep breath, right? That doesn't mean that we are going to throw our policies completely out of the window in those states.
I've definitely gotten that question, Sarah. So that is an important point to pause on.
Right.
No matter where we are, we can continue to prohibit being under the influence of marijuana while working.
Yes.
Possessing while working.
Or even using while working. Although I would think that would go hand in hand with being under the influence, but
Selling
who knows?
while working?
Sure. Yes, exactly.
That's for our entrepreneurial friends.
Yes. But for those who tuned in to episode 1, right, they know it can be difficult to distinguish between use outside of work and use during work or being under the influence during work. And that is because the testing we have is imperfect.
Correct.
A urine test only tests use within the last several days or even weeks. Right? So that doesn't really tell us anything about why somebody was under the influence when they were at work.
So, just like making any other employment decision, termination decision, where we can't terminate for certain reasons, but for others, we need to have objective,
correct,
reasonable basis for the decision.
You got it.
Am I right? So if we are in a state where we cannot terminate for just testing positive because we don't know what that means regarding the timing of the use. If you're going to make that termination decision, you must have objective, reasonable suspicion documented.
Yes.
Right?
And potentially exploring testing that narrows the window too. That's exactly right. So those ideas, as I called them in episode 1, right, to help employers manage that issue, when we start applying these state laws, they really become mandates.
Got it.
Right? If you've got employees in any of those states and you want to maintain a drug-free workplace, meaning maintain that standard of when people are at work, I think it's inescapable that you've got to have a reasonable suspicion program in place that includes training and all of those things we talked about, and also explore testing that can narrow the window of time to help us understand whether they used it outside of work or during work.
Got it. Okay, that makes perfect sense.
Okay, now we can have dessert.
Okay. Say, how nerdy am I that talking about the ADA is my treat for the day. But it is what it is. I am who I am.
That's why I love you.
And we are who we are.
That's right.
And I do think this is a question that comes up more and more, even in states where recreational marijuana is legal. It can still be relevant, right? The medical marijuana card.
Yes.
And the first question I get when I talk to clients about this, oftentimes they start with, I have an employee who is using marijuana for medically related purposes. They filled out the paperwork, et cetera. They have a known disability, et cetera. So let's not pause on that part of it. Let's just assume that to be true.
Right.
They say they need to use at work. Do I have to allow that as a reasonable accommodation? And it's usually followed up with, it's still illegal federally, right?
Yeah.
So can that be a reasonable accommodation? Do I have to allow it at work?
Under the ADA.
Under the ADA, because states can be very different on this. So
That's
let's
what I
just
was gonna
assume we're in a
say,
state
right.
that doesn't speak to this.
I'm sorry to offer you more broccoli, but I do have to say some states do also proactively require accommodation under their own state disability laws, right? Okay, so
first
let's
step is
just
to check
say
your
we
state
set
law.
that aside, right? And then and now we're having the conversation under the federal ADA, right?
Yeah.
So the current answer, Rebecca, is exactly what you alluded to, right? It is marijuana continues to be illegal under federal law.
Mm-hmm.
And also the ADA has a specific exclusion for illegal drug use. Okay. So generally speaking, most courts have said employers don't have to make exceptions to their drug policies for employees who are using marijuana for medical reasons or due to a disability under the ADA. That's the current legal landscape.
And to pause, just to state the obvious.
Yes.
Don't laugh. I know it's silly. But the ADA is a federal law.
Yes.
So often these conversations come up where they say, I know marijuana is legal now, but do I have to provide it as a reasonable accommodation? I'll often kind of rewind with the client and say, well, we're in the ADA world, which is a federal law, and marijuana is still illegal under federal law. So the premise, well, marijuana is legal now, is a false premise, right? When we're in the federal landscape.
Yes.
And I think it continues to surprise some people, or they skip over that fact that it is still illegal under federal law.
Right.
But as we know, Sarah, as people who study the court system and jurisprudence over the years and as it changes, oftentimes courts are at the forefront, right? And are more responsive to societal changes than Congress is, or even sometimes their state legislators, but almost always Congress, right? And they will find a way to get to the result that reflects the current state of society before law will actually be changed. Is there a way, because I'm sure that may take some people by surprise, right? That we would still tell an employee, well, marijuana is illegal, so we don't have to accommodate it. Is there, and I know that's the current state, is there a way that courts might get
Could
there?
start changing their minds,
Yes,
right? Yes.
Providing more protection to employees
and
who
this
use
gives,
marijuana?
Yeah, and the answer to your question is yes. So the ADA has an exclusion for illegal drug use, but then there is an exception to the exclusion. I love those.
It's a gift to lawyers.
It's a gift. Right.
Thank you for keeping us employed and making things so confusing.
And that is, the exception to the exclusion is for drugs taken under the supervision of a licensed healthcare professional. Now, when that was written, it was meant to include prescription narcotics, right?
Xanax, for instance, something like that does have street value.
Right.
It can be used unlawfully.
Yes.
It can also be used lawfully and
Correct.
prescribed.
Correct.
It just depends.
Correct.
Yes.
So far, federal courts haven't grabbed on to that argument. But I wholeheartedly agree with you that when I look at the landscape here, I truly believe that some federal courts are going to be looking for loopholes
Okay.
to change this, right? And it's similar. I just have to say this. It's so, in my view, it's very similar to what we were talking about 5 years ago with regard to protections for based on sexual orientation and gender identity.
Just
right?
what I was thinking.
Right. The laws didn't change, but the
Right.
courts found a way to interpret the word sex to include it, right? Generally speaking, I do tell clients that they should tread carefully in this area because I do think the law could change. Those court decisions could change, and they could be the test case, right? so
Fun for us, not for the client.
not for the
We
client.
would love to have the test case go up to the Supreme Court.
And the other thing I've got to point out too is all of this is based on the premise, of course, that marijuana continues to be illegal under federal law.
Right.
And there have been conversations for a long time about whether that will continue to be true, and those conversations are occurring today. So I see courts potentially shifting, and I also see potential for marijuana to become legal in some aspects under federal law, which could complicate it as well. Okay, so what does that all mean? What that means is you can make a decision based on the current state of the law, certainly. If the organization is not particularly willing to take any sort of risk, then I would say follow the course of the reasonable accommodation process, right? And to be honest, that leads us right back to the same place we keep finding ourselves in, which is even under the ADA. Let's just assume the ADA would require consideration of a reasonable accommodation because somebody is using marijuana due to a disability.
Okay, let's assume maybe it becomes legal under federal law.
Undoubtedly, I feel very comfortable saying it would be an undue hardship, though, for an employer to allow that person to be under the influence of marijuana while they're working, right? Or to possess it, or to sell it, or to use it during work.
Okay.
Does that make sense?
It does make sense.
However, it could be reasonable for that employee to say, please allow me to use it outside of work.
Mm-hmm.
And so if I test positive, please forgive me from that positive test, unless you can demonstrate or there's indication that I was actually under the influence when I was at work.
Yeah, I agree with you completely, consistent with the advice I've been giving as well. I see that evolving, just like we've talked about, how much this has evolved over the past 10 years.
Yeah.
I can imagine a world where we're not there yet, but where it would not be considered an undue hardship or an unreasonable accommodation for someone to be under the influence of marijuana while performing their job duties. I'm thinking of someone working from home.
I was going to say, depends on the job, perhaps.
Office work, it's sometimes prescribed for anxiety, similar to Xanax. And we certainly allow people, right, who are not operating heavy machinery or other types of things, right, to be on various types of anti-anxiety and antidepressives, right, while working, so long as it doesn't impair their safety or their performance of their job duties. And as the stigma of marijuana, right, as a recreational, illegal, dangerous drug continues to dissipate, that stigma continues to dissipate, I anticipate a world where it is possible that using marijuana while on the job could be a reasonable accommodation.
Could be. I would say it would be a narrow class of jobs to which that would apply, right? Operating machinery, driving, providing healthcare, right?
Right. Certainly
Services.
None of that.
Certainly wouldn't be the case. But I hear what you're saying with regard to somebody sitting at a desk and performing work. Not surprisingly, right, the ADA conversation led us back to the same place where we keep ending up, right?
That's why I love the ADA.
Which is this. We have got to be able to have a way to begin to distinguish being under the influence at work from using outside of work, right? We keep seeing that come up again and again. First episode, we talked about that in terms of employee retention and policies, right? Today, we talked about that in terms of those state laws, and now again, we're hearing it with regard to the ADA. So just to reiterate the importance of that, of those considerations.
Totally agree. Okay, excellent. Training.
I do have just one more thing with regard to the ADA, and that's because I see people forgetting this all of the time. If they get a request for accommodation because somebody is using marijuana for medical reasons, right? Certainly we don't have to let them be under the influence at work, as we discussed. But don't forget, that does trigger the accommodation process, okay? And that there could be other accommodations that person needs.
So what you're saying, this is something that employers often skip over. It's a process.
Yes.
So what employers should not do, let's just assume it's a request to be under the influence at work. Let's just say to have edibles, right? At work, for anxiety or whatever it is. And let's just say the client says no, right? That is, and we're saying that will often be,
that most will likely pass muster.
Most likely pass muster.
Yes.
But that is not the process. That is simply one step in the process.
Yes.
So we can't grant you the accommodation you requested.
Right.
Sarah, what else can we do? Are there other accommodations that would allow you to be successful in your position?
And comply with our policy to not be under the influence of a controlled substance or a prohibited substance while at work. That is exactly
That is the process. A process is not question and answer.
Yes.
A process involves discussion.
Yes. So don't forget that second piece.
Yep, that is an excellent point. And I almost did in this episode. So thank you for reminding me and everyone else to get to that next step.
All right. Well, great conversation. Thanks for the 2-part series. I appreciate it.
Yes, you too.